Thanks for coming. I'm delighted to participate in the election law series of the law school. My topic for today is shedding light on corporate political spending. This talk is going to be based on the work that I've done over the last 3 years or so on the rulemaking petition for disclosure of corporate political spending. It also builds on an article with the same title as that of the talk that Rob Jackson and I published a couple of years ago in Georgetown Law Journal, and on ongoing research that Rob Jackson and James Nelson and I are carrying out. Let me start by briefly describing the rulemaking petition that the talk is partly based on. So this rulemaking petition was submitted to the SEC in the summer of 2012 by a committee on the subject of disclosure of corporate political spending that was made of 10 academics. And the committee was co-chaired by Rob Jackson and myself, and it included 10 legal academics from various universities around the country with corporate and securities law expertise. Other members are listed here. Some of you with interest in corporate or securities law might know their names. They are very well-known people in the field with very different perspectives on the subject. They differ in their views on many issues of corporate and securities law, but on this issue, they all had the same and very clear view in favor of disclosure of corporate political spending. And what the petition did, relying on the possibility of asking the SEC to proceed with rulemaking, the petition using this procedure urged the SEC to initiate a rulemaking on the subject of disclosing political spending by public companies. In the 3 or so years since the petition was submitted, it received a very substantial support. The SEC has a comment file, and it has received over 1.2 million comments on the petition. Most of them, I should note, were form letters that people filed. But each of them had to take kind of an individual action to fax or to email the SEC. And there are also thousands of distinct comment letters, detailed comment letters that were filed by institutions, firms, and individuals. And that volume of comments is unprecedented. There are far more comments on this rulemaking petition than on any other petition in the history of the SEC, and indeed also on any proposed rulemaking by the SEC itself. The overwhelming majority of the comments that were filed were, including those by many institutional investors that filed comments, were supportive of the petition. And one submission to the SEC that might be worth highlighting is one that we were pleased to see in the spring of last year. It came from a bipartisan group of former SEC commissioners, including former SEC chairman William Donaldson, who was appointed by President Bush, and former SEC chair Arthur Levitt, who was appointed to his position by President Clinton. And they, in fairly strong submission, they wrote to the SEC and expressed the view that it's a slam dunk for the agency to move forward with the proposed rulemaking, and that failing to act, given what the petition put forward, and the comment file, quote unquote, flies in the face of the primary mission of the Commission. The SEC seemed to be initially receptive to the petition. In November 2012, several months after the petition was submitted, the director of the SEC Division of Corporate Finance, the division that has primary responsibility for subjects like the proposed rulemaking, spoke at the conference, indicated that the division was actively considering the petition, and observed that it is a subject that obviously involves an issue that is extremely important to many. And later this year, the SEC, it has a regulatory agenda for the subsequent year that it issues, and the SEC placed this topic on its agenda for 2013 and indicated at the time that it expected that the consideration of the issue is going to result in a notice of proposed rulemaking. So things seemed hopeful for rulemaking in this area. But politics intervened. In 2013, the subsequent year, Mary Jo White became SEC chair, and she already faced in the confirmation hearing a very substantial political pressure, a great deal of resistance with legislators pressing her to promise not to initiate rulemaking on the subject. And at the end of 2013, the issue was removed from the regulatory agenda of the agency for the subsequent year. Last summer, 44 US senators sent a letter to the SEC asking it to make the petition, quote unquote, a top priority. However, this past December, the omnibus budget agreement included a rider that prevented, by denying funding for this purpose, prevented the SEC from issuing the proposed rule in 2016. And this is the limbo in which the subject is at present. You might wonder, there were 44 senators who intervened, sending the strong letter to the SEC chair. But obviously, there was a majority in Congress to include a rider preventing the SEC from doing it. At the current time, most of the resistance to rulemaking in Congress comes from Republican legislatures. But it's worthwhile noting that this is not a sentiment that is shared by Republican voters. Indeed, according to a recent poll, disclosure of political spending is supported by close to 90% of both Democratic primary voters and Republican primary voters. So this is one issue where support among voters, support among the citizenry is bipartisan, widespread, very, very broad. So this is the brief history. But let me turn to the substantive arguments, because in my view, and what I'll try to argue to you in the next 15 minutes or so, that despite the substantial political roadblocks, the substantive case for rulemaking is very strong. Okay, we should start with just putting on the table a factual point that might be familiar to many of you who attended earlier sessions of this election law series, that substantial part of the spending that comes from public companies is made under investors' radar screen. Why is that? There are two reasons. One is that some spending is done through intermediaries, such as the US Chamber of Commerce and many other intermediaries. And those intermediaries do not have to disclose their own supporters, and therefore money that is channeled to political causes through such intermediaries, investors cannot identify, because there is really no public record that even for someone who is willing to spend a lot of effort can enable tracking funds to the corporate donors. It seems that there is a lot of money coming through this channel. For example, the US Chamber of Commerce has spent more than $100 million since 2008 on politics. And there are reasons to believe, I'm happy to discuss why in the Q&A, there are reasons to believe that a substantial fraction of these funds come from public companies. Then there is some funding that comes from companies for which there is a public record somewhere. That's money that is given to super PACs, money that is given directly to state or federal officials. There is public record somewhere, but piecing together that there is going to be a lot of different public records for different contributions, and piecing together the picture of the aggregate contributions that a particular public company made is going to be a very substantial effort. We actually had a research associate try to use public records to piece together the picture of political spending by a number of large, well-known companies. And it was a fairly substantial undertaking that took several days of work for any given company. So this is something that therefore makes information that is in principle out there, it makes it inaccessible to most investors in a way that can be used by them. So the information is not out there. It's not in the hands of investors. And let me say why it would be valuable for them to have this information. This is a topic different from many other business decisions that companies make, on which the preferences of managers and directors might well substantially differ from the preferences of those investors whose money is being spent. That's kind of an obvious potential agency problem. And the Supreme Court in Citizens United was aware of it, potentially concerned about it. And Justice Kennedy said that to prevent corporate insiders from spending on politics in ways that shareholders do not support, that shareholders disfavor, one can rely on, quote unquote, the procedures of corporate democracy. Those are essentially the ability of shareholders to vote out directors that spend money in a way that they disfavor. But obviously, such procedures cannot work. There is really no way for them to carry out their intended role if investors do not know how money is spent on politics. I should note that disclosure is especially important here because political spending has, quote unquote, expressive significance. And in addition, it might involve risks to the company. And those are things that go beyond the amounts involved. And that's why investors, or some investors, might reasonably be expected to attach greater significance to how money is spent on politics beyond just the dollars, the number of dollars involved. And there is evidence that investors are indeed keenly interested in this type of information. In recent proxy seasons, shareholder resolutions asking for disclosure of political spending have been the most common type of a proposal, more proposals of this kind than on any other corporate governance subject. And those proposals have gained substantial support. This support, by the way, has led to steps taken by a significant number of S&P 500 companies that, trying to be responsive to shareholder preferences expressed in such votes, adopted voluntary disclosures. And some of the people who oppose a mandatory SEC rule have been relying on those voluntary disclosures, saying that they make it unnecessary to have a mandatory rule. They said, to the extent that investors are interested, this can be fully addressed by voluntary disclosure. In our view, however, voluntary disclosure is in no way substitute for a mandatory SEC rule, as is the case for many subjects of disclosure, where SEC rules require disclosure rather than leave an issue to voluntary choices by companies. First of all, if one looks at the voluntary disclosures out there, one can see that many voluntary disclosures are incomplete because the companies choose what and what not to include, how to define the scope of expenditures that are included. And sometimes there is evidence of some significant loopholes that lead to significant spending not being made transparent. Moreover, even if we didn't have those problems, when companies each chooses its own form of disclosure, investors do not have the kind of uniformity, the kind of standards that facilitate and make it possible for them to make comparisons across companies. Furthermore, until now, we have had voluntary disclosures following a lot of work by investors in a significant number, but still a minority of S&P 500 companies. But we have thousands of public companies. And for investors to try to engage with those companies and try to get voluntary disclosures for most of them would be a massive uphill effort that would take many, many years to complete. And finally, even if in many years from now we could get most companies, let's say 70% of the companies, to disclose voluntarily, we have reasons to be concerned that the 30% of the companies that won't be disclosing voluntarily would be disproportionately ones that, quote unquote, have something to hide. That the reason why they won't be disclosing is because they are more likely to be doing things that they feel investors might be unhappy about. And that's yet another reason why we shouldn't just rely on voluntary disclosures, but proceed to a mandatory SEC rule. That's going to be, in a nutshell, the case for a mandatory rule. Obviously, you might wonder, what are the potential objections for such rulemaking? And even though the SEC has not yet started the process, we have the benefit of the substantial SEC file, comment file, that has been created following the submission of the proposal, because even though the overwhelming majority of the comments have been supportive of the petition, there is a significant number of detailed, lawyerly, substantial submissions by organizations like the US Chamber of Commerce, other organizations, with trying to put forward objections to rulemaking. And what we have done is to go over all those objections, categorize them. And our own conclusion is that those objections do not, either individually or collectively, provide a good basis for opposing transparency. Let me just give you a sense. I won't be able to review all the objections that have been made in the file, but let me go quickly over a number of objections that have been recurring, that have been made, have been pressed by more than one submission, and seem to have been given weight by opponents. One objection is political spending is good for shareholders. This is something that is under debate. There are empirical studies in both directions. Professor Coates from our law school has done empirical work suggesting that some spending isn't beneficial. But from our perspective, the most important issue is not whether spending is on average beneficial or not, because that doesn't really, for us, eliminate the need for disclosure. Because even if one takes the view that most spending, or that spending on average is beneficial, there's really no reason to think that all spending by all companies in all times is beneficial. And that means that shareholders should be permitted, should be given the ability to form their own views on whether their own company spending is beneficial. And they cannot form such a view without being given the basic facts as to how much the company spends and on what political causes. A second objection is disclosure is going to be used or abused by special interests who are going to use the disclosure in order to gain leverage over a company and press it to do things that are not going to be beneficial for shareholders. So that's the fear of the process being hijacked by special interest. But if you think about this problem, special interests are not going to be able to gain any leverage over an issuer as a result of disclosure unless what is disclosed is something that reveals spending that is not supported by most shareholders. Because if you reveal something that shareholders like, that is just going to strengthen your position among shareholders. And is not going to be subject for good criticism. And therefore, the only thing that companies will have to worry about is if they do spending that doesn't get the support of shareholders. And such spending should indeed be discouraged. A third objection that comes often is, look, this is just not material. Corporate America has trillions of dollars in assets, massive profits. This is just small change. And investors, being rational economic beings, are just not interested in such small change. The first thing to note is that this is a bit of a curious claim, because how can you claim that this is a small change if we don't really have the numbers, so that we don't have how much each company is giving. And therefore, there's really no way for anyone to say with any confidence that for companies in general, the amounts involved are not material. Moreover, there are various things that the SEC requires disclosure where the numbers are not large. Perhaps smaller than the amount involved in political spending. So for example, the threshold for disclosing related party transactions or perks to executives. The threshold is very low, $10,000. But the SEC still provides disclosure, not because the amounts are large, but because it takes the view that for those types of expenditures, investors would have an interest in knowing, even if the numbers are not large. And political spending, we take the view, is such an expenditure. It's an expenditure that means more for investors than just the numbers involved. And I already noted both the expressive significance and the risks to the company that political spending might pose. Next, there are claims that even if this is somehow substantively desirable, it's just inappropriate or impermissible. And I'll mention two objections here. There are several objections of this kind. One objection is this is just illegal. It violates the First Amendment. to us, this seems to be a claim that is not well-based. The Supreme Court has recognized in a series of cases that disclosure is different than substantive restrictions. Disclosure doesn't prevent anyone from speaking. Indeed, it can be viewed as promoting some First Amendment values. And indeed, the Citizens United itself upheld by a large margin the disclosure requirements that were involved in this case. And this was subsequently followed by a number of lower court decisions. Lastly, another objection in that category of saying even if this is substantively good, it's something that is inappropriate or impermissible, there is the argument that the SEC should just stay out of it. It should stay out of election regulation. It should stay out of politics. So first of all, on election regulation, the argument is we have other agencies with expertise. The SEC has no expertise on elections. It should stay out of it. But the argument for disclosure here, it's not that disclosure is needed to benefit the electoral process. For that, we indeed have other agencies. But rather, this is to protect investors. This is to protect the use of other people's money. And this is an investor protection argument. And for this, the SEC has ample expertise in providing the type of disclosure that investors need and want. Lastly, there is the argument of this is a hot potato. It involves politics. It has effect on politics. The SEC, to protect its high standing, its professional status, should try to stay away as much as it can from things that implicate or can have an effect on the political arena. In our view, this gets the issue wrong, because this is a rule that the SEC should do for investor protection reasons. Shouldn't do it for with a political motivation of producing this or that political consequence. But if it does have an investor protection reason for doing it, then failing to provide such information would not represent an attempt to stay out of politics. On the contrary, it would let the fear of political consequences, it would let political considerations keep the SEC from doing its job. Okay, let me then conclude by just stating kind of basic conclusions that the case for a mandatory disclosure in the form of a mandatory SEC rule is very strong. That consideration of such a rule has been held back by political pressures, not valid substantive objections. But the strengths of the case and the widespread support for it provide the basis for optimism going forward. And I hope that before too long, public companies would indeed be required to disclose their political spending to the investors whose money is being spent. Thank you, and I'll be happy to.
Hi, thank you for the talk, Professor Bebchuk. My understanding of your argument for disclosure of political contributions is that it rests not only on a kind of conception of agency problems, but also you couched it in the language of corporate waste, kind of saying a couple of times this was the directors that were using the investors' money in ways that they didn't agree with. Does that kind of force you to draw the line between pecuniary political actions and non-pecuniary political actions. I'm thinking about something that a company could do that has political effects, but is not necessarily a donation. And I'm wondering, if you have to draw that line, what are the repercussions of that?
I wouldn't view this issue as a corporate waste. If one were to take the view that political spending is corporate waste, then one would conclude that political spending should be prohibited, period. Because corporate insiders are just not allowed to waste corporate assets. So I do take here kind of an agency concern, take the view that insiders are allowed, and indeed legally one has to take this view given Citizens United, because the Supreme Court has spoken to the proposition that companies are permitted to spend, and therefore if companies are permitted to spend, then their decision makers are the ones that have to initiate it. So my concern is just the standard agency concern, similar to, say, an executive compensation problem. With executive compensation, we are concerned that some executive compensation might be beneficial, but we worry that insiders might make decisions that deviate from shareholder interest. And for this reason, we, at the minimum, provide very substantial disclosure. We provide transparency so that the mechanisms of corporate democracy can work. On the second question of pecuniary versus non-pecuniary, I think that it would be very difficult to, from the outside, to draw such distinctions. What I would like to see is transparency, and then have the mechanisms of corporate democracy do their job.
So, sorry, if I could just really quick follow-up. The disclosure rule will then also apply to non-pecuniary actions that the company takes that are political in nature? Because I think that could involve a
so you are saying,
wider
you're saying,
of actions.
The question is, what would be an example? If you are saying, if this is something that, let's say, they give a speech or they hold a fundraiser, in a way, one can rely on the standard rules as to what is political spending. So there are now standard rules as to political spending that has to be disclosed if it's done directly, right? And we can rely on them. The problem with corporate political spending, we don't need to invent a new definition of political spending. What we need is just to remove two barriers that prevent something that under the existing rules is clearly political spending from being hidden. And the reason why it's hidden is because the money might be channeled through an intermediary. When it gets to the political arena, there is no question. The US Chamber of Commerce would have to disclose this. There is no question that this is political spending. The problem is that there is no way for investors to know where the money came from. And similarly, if you think about the hundreds of very different pieces of public records that be needed to be pieced together for investors to form an aggregate view as to what the company is doing, there is already a legal judgment that those are political spending expenditures. And therefore, we can rely on that.
It's really important work. I really want to follow up on the intermediary point, because Chamber of Commerce, trade associations, so many other intermediaries already exist. And even if the disclosure requirement were put in place, wouldn't new ones be created? Is there a way to design the disclosure requirement that it would reach back to the company?
Yes. So the rule that, if we don't have disclosure requirements that enable investors to see through the intermediaries, we haven't done all that much. So what we proposed is, and obviously there would be all kinds of particular implementation issues for the SEC to design, but in general we propose that companies will have to disclose when they give money to intermediaries of a certain kind, intermediaries that spend enough of their own money on politics. And obviously, one would need to engage in some line drawing, but that is the basic approach, because our view is that this is something that investors would want to know. Indeed, the several dozen companies that right now disclose political spending, they disclose how much money they give to the Chamber of Commerce if they contribute to the Chamber. Yes?
Thank you. I realize this question may pertain to a challenge to the Citizens United case rather than to the measure that you're just suggesting. And sorry I'm late, but suppose you have a hypothetical oil company like ExxonMobil, and it's receiving subsidies from the government to enable it to reduce the price of gasoline, which is not such a silly supposition. But suppose then that ExxonMobil started to fund a political action fund that was in supporting candidates who were supporting the continued dependency upon fossil fuels and oil and coal. Should the voters, not the voters of ExxonMobil, but the voters in the public, wouldn't the level of political discourse be considerably elevated if the public if it was required that ExxonMobil disclose both the subsidies that it was receiving and the spending and the fact that it was lobbying certain candidates to continue those subsidies and to oppose any measures which would retract those subsidies, and was opposing subsidies to non-fossil fuel-based companies.
No, I hear you. I understand the sentiment that is behind your observation, but this indeed goes beyond, both beyond what we are trying to do with this rulemaking petition, and also beyond my expertise. So. This is something that if you want to fix politics, or if you want to fix the electoral process, one can take views on those issues. Our interest here is not in electoral improvement. Our interest here is in a particular problem that is connected, which is the use of other people's money. The problem that you have in mind, for example, would exist if a company spent, even if it was a company that had a sole owner. Our interest in this whole body of work is focusing just on the use of other people's money by public companies.
Hi. Excuse me. Sorry. Thank you for your presentation. So if I understand what you're saying, that the sort of end result would be the ability for shareholders to push back in some way on companies for their political spending activity because it is at odds with the political inclinations of investors? Would there be some kind of, other than just divesting themselves of their holdings of the public company, what type of action could investors take on a company if they found out that the company was spending its funds in a way that it somehow collectively opposed?
Yeah. So basically, once you have disclosure, people have different views as to whether you need to supplement it with additional powers for shareholders to intervene. And Rob Jefferson and I have an article in the Harvard Law Review 4 years ago or so talking about this question of whether investors should have powers, for example, to approve the level of political spending. But people might have different views on this. So for example, there are some people who might take the view that once you have disclosure, then this would be sufficient because this would deter directors from doing things that displease investors, because directors would be concerned that this is something that, at least on some margin, might reduce their chances of reappointment and so forth. And there might be disagreement on whether a just disclosure would be enough or not. What I have been trying to do, what we have been trying to do in this work, is to say, whatever your views about how the mechanisms of corporate democracy work, how much they are sufficient to get shareholder preferences to dictate outcomes. Disclosure is something on which there should be complete agreements because it should be the first step. Whether or not it's a sufficient step, it's a different discussion, and people have different views. And my own view is that it would be beneficial to have some additional arrangements. But, yes.
I was trying to think of in what cases would disclosure actually harm shareholders. And one of the situations I thought of is a situation in which it actually goes to the consumers of the company. The disclosure isn't just to the shareholders. The disclosure is to the general public. And while it might be profitable for a company to give political money to promote its agenda, it might harm it on the consumer side. So say, I don't know, I'm making it up, Google donates to someone to make sure that regulation doesn't limit its activities. It helps the shareholders' profits. But if consumers of Google's services find this out, they might pressure the company to stop making these donations. And then in these senses, these are specific situations which might hurt shareholders, because shareholders are actually benefiting from the donations because it improves the activity of the company, but consumers might pressure it to stop these donations.
Sure. Yeah, I understand this point, and it's an argument that has been raised by some opponents, and theoretically it can exist. The question is, should we let it carry the day? Because obviously, companies cannot speak to their investors through a private channel. So whatever they broadcast to their investors in the public space, and it's going to be heard by everyone else. Now, if you try to place weight on this argument and to see whether it should lead you to abandon disclosure, you might notice that you can make a similar argument about other things that companies now disclose to their investors. For example, companies now disclose their compensation level to investors. You could say, maybe the investors are happy that the CEO is making $100 million, but this might annoy some employees and might hurt morale. Or you might say, look, maybe the shareholders would be happy to hear about. So you can see that you can make many arguments like this. And if you were willing to rely on this kind of speculative effect in kind of an uncertain number of cases, to let companies just say, look, we would have liked to tell you, but we can't really tell you, so we'll just count on us because we can't really tell you in secret, and therefore then I think that a lot of existing disclosure rules would have to be eliminated. And to me, this kind of an effect seems to be sufficiently speculative in terms of magnitude as not to carry the day, to hide information for which we have reasons to believe that investors are keenly aware of, keenly interested in, kind of in a large number of cases.
I think I have 3 connected questions. First, how do the large institutional investors stand on this proposal? And I'm wondering if they were active in the proposed rulemaking, and if any of them opposed it, what were their reasons? Second, how many of the proxy proposals for mandatory disclosure have been successful? And third, it sounds like it wasn't a ton that were successful, so doesn't the fact that a lot of companies, their investors haven't demanded this, what do you make of the argument that the fact that shareholders haven't demanded this yet shows that it's not really needed?
Okay. Basically, not all institutional investors have spoken on this subject. Many of them have spoken, or all had to speak through voting on precatory resolutions. So you can look at that. Now, precatory resolutions, by and large, there is substantial difference from company to company, but they get a substantial plurality, but they don't pass. Okay? The substantial plurality comes not just from institutions that are viewed to be more, quote unquote, interested in social responsibility issues, like public pension funds, but also comes from some mutual funds. So MFS, for example, or TIA-CREF largely vote for such proposals. But there are indeed some large institutional investors, for example, Fidelity and Vanguard, that generally do not vote in favor of such proposals. One thing that I would mention here is that you can't infer from their voting on proposals from their view on a general requirement, because what the view that some of them take is, look, if we had a general requirement, that might be fine, but we just don't like when a shareholder picks a particular company and asks it to make disclosure that its peer companies are not equally and uniformly required to follow, and we might have a different view, or we might not, if you had the general rule. So the last question that you raised, and this is something that opponents have raised, which is, look, if it doesn't get majority, then we shouldn't really follow it, because you could say the majority opposes it. Now, if we look at the history of disclosure requirements, the SEC has in the past, when things were viewed as being desired by a significant fraction of shareholders, not a majority, the SEC viewed it as sufficient interest to require disclosure. In a case that is somewhat analogous, in the early 90s, there were proposals to disclose more information on executive compensation. Those proposals got less support than currently political spending resolutions get, but the SEC said, look, if 15, 20% of investors want some information, we think that this is sufficient interest to signal that we should provide this information. Partly they might be influenced by the fact that there is, among institutions, kind of some reluctance to vote against management in shareholder proposals. So therefore, a 20, 30, 40% vote is viewed as a meaningful support for a certain position. Just to give you a perspective, if you think about many of the social responsibility resolutions that companies have been responding to, whether it's Darfur, South Africa, or issues like that, they generally received lower level of support than the political spending resolutions get now. But companies view this as, look, this is a meaningful support. And lastly, I just mentioned that there are various companies that had shareholder resolutions receiving significant support, but not getting majority, and that moved to voluntary adoption, thinking that this is a good corporate practice. If they took your view, they would say, oh, actually, we should affirmatively not voluntarily disclose because the majority of the shareholders asked us not to do so. But the way they think about it, and the way that in general responsiveness to shareholder proposals is viewed, is when something is desired by a significant number of the shareholders, responding to it is not defying the will of the majority. Because usually, and this is, I'll stop, this was a long answer. Usually, when 30% of the shareholders want something and the others do not vote for it, it's often the case that the majority is just not affirmatively demanding it, doesn't think that this is something on which management should be pushed, or that this kind of overcomes their general reluctance to vote with management. So 30% really want it. The others are just not at the point that they think this is something they should be pushing for, but it's not something that they are affirmatively against.
Thank you. Just to definitional question. When you say political contributions, this includes money given to specific interest groups that are not formally identified with one or another candidate in the elections?
Yeah, super PACs, yes.
Right, okay. Now, on that, do we know much about the nature of these contributions, even though we don't have statistics? For example, I might surmise, but I might be dead wrong, that corporations being what they are, and shareholders tending to be richer than people who don't own shares, you're going to find things more on, say, the conservative or Republican side of what tax policy should be on this or that issue, or what a trade agreement should be, and so on. So do we know whether there's a very strong valence, other kinds of research or what, in how these corporate political contributions work? Do they get into gay rights, mandatory sentencing in criminal cases, whatever, 101 things, or are they mostly on matters that are very close to the economic interests and bottom line of corporations?
Okay. I think that there are some contributions that are very direct, and you can connect to a particular cause. For example, some corporates have contributed a lot of money in connection with state law referenda on issues that were directly connected to their business. But very often, what the companies will do is contribute to a particular candidate. Okay, and the candidate is obviously a package. It's a bundle of positions. Now, the corporation might be interested only in very particular positions of this candidate, or maybe in some future positions. But obviously, we cannot disentangle and know the motivation. So if you think about if a financial institution will be contributing to the chair of the banking committee in the Senate, maybe they have a particular position, but they would be contributing to the person, and therefore to the full bundle of views and positions coming with the person. Thank you very much.